we have come to the last part of our syllabus. The last part, which is on the topic of the rules of interpretation or construction of contracts. And this will be the last lecture for the semester for our class on statutory construction. Just like in the previous lectures, I will leave to you the responsibility of reading and studying the full text of the cases listed under this topic. And just like in the previous lectures, I will just discuss the pertinent rules, concepts, and principles for the subject matter. And before I forget, I have been informed that the schedule of the final exams will be sometime in July. So until the schedule of the final examinations has been posted, you still have more time to study for your final exams and to complete your case digest. So good luck. Okay. So let us proceed with the last lecture for this semester under our subject statutory construction on the topic of interpretation or construction of contracts. Okay. So first and foremost, let us have a review on the meaning of contracts, which I know you have taken up in your obligations and contract subject. So what is a contract? We all know that under 1305 of the New Civil Code of the Philippines, a contract is a meeting of the minds between two persons whereby one binds himself with respect to the other to give something or to render some service. And as you also know, under your obligations and contracts, contracts have the essential requisites as that of the obligations, as that in obligations, which are consent, object or prestation, and cause or consideration. And in connection with that, you also studied about the characteristics or contracts or principles of contracts, which aside from the principle of consensuality, we have the principle of relativity, mutuality, and autonomy of contracts. These are important because these are connected to and connected with the subject matter and interpretation and construction of contracts. So let us recall that the principle of relativity, which is provided under Article 1311. So under the principle of relativity of contracts, it states that contracts take effect only between the parties, their assigns, and heirs, except in case where the rights and obligations arising from the contract are not transmissible by their nature or by stipulation or by provision of law. And under the principle of mutuality of contracts, which can be found in Article 1308 of the New Civil Code of the Philippines, it states that the contract must bind both contracting parties. Its validity or compliance cannot be left to the will of one of them. Okay. So this principle states that the obligations arising from contracts have the force of law between the contracting parties, and there must be mutuality between them, which is based essentially on their equality, and under which it is repugnant to have one party bound by the contract while leaving the other free therefrom. And the ultimate purpose is to render void a contract containing condition which makes its fulfillment dependent solely upon the uncontrolled will of one of the contracting parties, as this was held in the case of Allied Bank Corporation versus CA. Okay. And going back to the principle of relativity, of course, in connection with what we stated under Article 1311, contracts can only bind the contracting parties and it cannot favor or prejudice third persons. And even if the third person has knowledge of such contract, and if he has no privity of the contract, then he does not have rights or obligations under that contract. And we have the principle of autonomy of contracts, which can be found in Article 1306 of the New Civil Code of the Philippines, which states that the contracting parties may establish such stipulations, clauses, terms, and conditions as they may deem convenient, provided they are not contrary to law, morals, good customs, public order, or public policy. So the contracting parties can include a choice of law clause in their contract, stating the validity and interpretation of their agreement. Okay? And this is not an absolute rule, however, because as we said under 1306, it has limitations. So the stipulations of the parties must not be contrary to law, morals, good customs, public order, or public policy. Also, the principle of autonomy of contracts is counterbalanced by an equally important rule that provisions of law, especially those affecting matters involving public policy, are deemed written into contracts, as this was held in the case of Industrial Personnel and Management Services et al. Versus De Vera et al. Okay. Another important thing that you must remember is the distinction between interpretation and the reformation of contracts, because they are two different things. So, in interpretation, this is the act of making intelligible what was before not understood, or unintelligible, or ambiguous, or not obvious, and that this is a method by which the meaning of language is ascertained. While when we say reformation of contracts, this refers to the remedy in equity by means of which a written instrument is made or construed so as to express or conform to the real intention of the parties. And in the case of National Irrigation Administration versus Gamit, the court distinguished between contract interpretation and contract reformation. Okay, so just to give an emphasis, let me read to you that the court stated that interpretation is a method by which the meaning of language is ascertained. The interpretation of a contract is the determination of the meaning attached to the words written or spoken which make the contract. On the other hand, reformation is that remedy in equity by means of which a written instrument is made or construed so as to express or conform to the real intention of the parties. The Supreme Court further held that in granting reformation, equity is not really making a new contract for the parties, but is confirming and perpetuating the real contract between the parties, which, under the technical rules of law, could not be enforced but for such reformation. As aptly observed by the Code Commission in this case, the rationale of the doctrine is that it would be unjust and inequitable to allow the enforcement of a written instrument which does not reflect or disclose the real meaning of the minds of the parties. Excuse me. Also, the Supreme Court held that the principles of statutory construction can be applied in the interpretation of contracts, considering that the rules of statutory construction take into account the meaning of the words used in a legal instrument. Okay, so now we move on to the legal provisions on the interpretation construction of contracts. So this can be found, as you know, as you have taken up in Oblicon, in Articles 1370 to 1379 of the New Civil Code of the Philippines. Okay, let's breeze through them one by one. So Article 1370, if the terms of a contract are clear and leave no doubt upon the intention of the contracting parties, the literal meaning of its stipulation shall control. If the words appear to be contrary to the evident intention of the parties, excuse me, the latter shall prevail over the former. So in terms of a contract, when the contract is clear and unequivocal, then the parties are bound according to the literal sense or literal meaning of their stipulations in the contract. But in case of a conflict between the words of the contract and the evident intention of the parties, of course, the intention of the parties shall prevail, or the real intent shall control. For example, as to the literal meaning or literal sense of the stipulations in the contract or the wordings of the contract. If there are two parties, A and B, and the contract was executed between A and B, stating that it is a sale of a land belonging to A, for example, worth 500,000, then the terms of the contract are clear and it does not appear that there is any other intention of the parties which is contrary to the literal meaning of the said term. So this is a contract of a sale of a parcel of land. Okay. In 1371, in order to judge the intention of the contracting parties, their contemporaneous and subsequent acts shall be principally considered. So we have discussed this before about contemporaneous and subsequent acts with respect to construction or interpretation of statutes. Okay, so here, contemporaneous and subsequent acts to the celebration of the contract with its antecedent circumstances under which it was made may also be considered in judging the intention of the contracting parties. Okay, so for example, again, A and B, they entered into a contract of lease. The contract states that the possession and ownership of the land are transferred to B. Then the title of the land was given to B, and then B registered the land in his name. And before the date of the contract, A even wrote a letter to B offering to be the sale of the land. So by their acts, you can see that the parties clearly indicated that their evident intention is to make B the owner of the land, or that the evident intention is for A to sell to B the land. So even if the contract states that it is a contract of lease, the contract should be interpreted as one of a contract of sale. Okay. Next, 1372. However general the terms of a contract may be, they shall not be understood to comprehend things that are distinct in cases that are different from those upon which the parties intend to agree. So here, the special intent prevails over general intent. As a general rule, where in a contract there are general and special provisions, and they cover the same subject matter, the special provisions shall prevail or control over the general provisions when they cannot stand together or when the two cannot be reconciled together. So the contract shall be limited only to those things or cases which the parties intended to agree. 1373. If some stipulations of any contract should admit of several meanings, it shall be understood as bearing that import which is not most adequate to render it effectual. Okay. So here it refers to interpretation of stipulations with several meanings. So if one interpretation makes a contract valid and another interpretation makes the contract illegal or invalid, then the valid interpretation is one which is warranted by the rule. Okay. So if, for example, A and B again, A sold a parcel of land to B for 500,000, but A has two lands. So the one land owned by A is owned by A only, and then the other land is owned by A with a co-owner. So here, the one sold without a co-owner or without A's co-owner shall prevail. Okay, meaning the land owned by A only is the one which is sold as the parcel of land to B for 500,000 pesos. Okay. Let's lump together 1374, 1375. The various stipulations of a contract shall be interpreted together, attributing to the doubtful ones that sense which may result from all of them jointly. And words which may have different signification shall be understood in that which is in keeping with the nature of the object of the contract. Okay, so the contract should be read and interpreted altogether in its entirety or as a whole to give effect to all its provisions. So it's like what we discussed before under the constitutional construction of interpreting the provisions of the Constitution as a whole in its entirety and harmonizing all the provisions to give effect to them. Okay. Going back to contracts, interpretation of contracts. So in case of conflicting provisions, the stipulations in the contracts must be reconciled and interpreted as to harmonize these with one another or with each other. Okay, so in case of conflicting provisions, stipulations in the contract, the same must be considered, reconciled, and interpreted so as harmonize them with one another. Okay, example, if again A and B, if A leased his house to B, and in the contract it was stipulated that B should not sublease the house without the consent of A. And if B should sublease the house without the consent of A, then B would pay 1,000 per month as penalty. Okay, so if he violates the condition given stipulated in the contract, then B will pay A 1,000 per month as penalty. And what happened was that B subleased the house without the consent of A. So here, A will not eject B in the light of the provisions or stipulations in the contract that the penalty for violation of the condition is to pay 1,000 per month instead of ejectment. Okay. So in as to the interpretation of words with different significations, so if the word is susceptible of two or more meanings, so it is understood to be the one most in keeping with the nature and object of the contract based on the intention of the party shall be the one that will prevail. Okay. 1376. The usage or custom of the place shall be borne in mind in the interpretation of the ambiguities or ambiguities of a contract, and shall fill the omission of stipulations which are ordinarily established. Okay. So here, simply put, the usage or customs are used as aid in interpretation of contracts. Okay, so the usage and custom of the place where the contract was entered into may be received as to what is doubtful or ambiguous in a contract on the theory that the parties entered into their contract with reference to such usage or custom. 1377. The interpretation of obscure words or stipulations in a contract shall not favor the party who caused the obscurity. So, a written agreement should be interpreted against the party who has drawn it, or be given interpretation which shall be favorable to the other, who upon the faith of which has incurred an obligation. 1378. When it is absolutely impossible to settle doubts by the rules established in the preceding articles, in doubts refer to incidental circumstances of a gratuitous contract, the least transmission of rights and interests shall prevail. If the contract is onerous, the doubt shall be settled in favor of the greatest reciprocity of interests. If doubts are cast upon the principal object of the contract in such a way that it cannot be known what may have been the intention or will of the parties, the contract shall be null and void. And 1379, the principles of interpretation stated in Rule 123, which is now Rule 130 of the Revised Rules of Court, shall likewise be observed in the construction of contracts. Okay. So the rule, in case doubts are impossible to determine as to the principal object, the contract is null and void. And the object must be certain, otherwise, if it is not known, there is no meeting of the minds between the parties. And in case doubts are impossible to determine as to the incidental circumstances, they're different with respect to gratuitous or onerous contracts. So if gratuitous or gratuitous, the least transmission of right and interest will apply. If it is an onerous contract or burdensome contract, then the greatest reciprocity of interest shall prevail. Okay. So now we move on to the rules, principles, and doctrines enunciated by the Supreme Court in several cases. Okay? So in the case of Lambert versus Fox, the Supreme Court discussed the importance of the language used by the contracting parties in a contract. So it held that the intention of parties to a contract must be determined, in the first instance, from the words of the contract itself. It is to be presumed that persons mean what they say when they speak plain English. Interpretation and construction should be the instruments last resorted to by a court in determining what the parties agreed to. Where the language used by the parties is plain, then construction and interpretation are unnecessary, and if used, result in making a contract for the parties. Okay. In the case of Bautista versus Court of Appeals, the Supreme Court held where the language of a written contract is clear and unambiguous, the contract must be taken to mean that which, on its face, it purports to mean, unless some good reason can be assigned to show that the word should be understood in a different sense. Courts cannot make for the parties better or more equitable agreements than they themselves have been satisfied to make, or rewrite contracts because they operate harshly or inequitably as to one of the parties, or alter them for the benefit of one party and to the detriment of the other, or by construction, relieve one of the parties from the terms which he voluntarily consented to, or impose on him those which he did not. Okay. So, in connection with 1371, okay, this rule is based on the reality that while courts cannot determine with certainty the intent and state of mind of the contracting parties, their actions contemporaneous to or subsequent to the execution of the contract serves as evidence of their contractual intent at the time of its execution. Okay. In 1372, a provision in a contract should not be expanded beyond what it intended to cover. So in the case of Empire Insurance Company versus Rufino, the Supreme Court held that the rule that particularization followed by a general expression will ordinarily be restricted to the former is based on the fact in human experience that usually the minds of parties are addressed especially to the particularization, and that the generalities, though broad enough to comprehend other fields if they stood alone, are used in contemplation of that upon which the minds of the parties entered. Okay, this is also in connection with special provisions prevailing over general provisions. Next, in connection with 1377, okay. In the case of Orient Air Services versus Court of Appeals, the court laid down the rule of contra proferentem. This rule means that ambiguous provisions in the contract shall not benefit the person who drafted it. And in 1379, okay, so rule of interpretations or principles of interpretation stated in the rules of court, excuse me, from sections 10 to 19, actually supposed to be sections 9 to 19 of the revised rules of court, rule 130. In the discussion of the new or revised, their most recent revised rules, there were no discussion by the speakers, Attorney General Salvador and Judge Henrito, regarding the amendments of this provision. So, since there are no amendments, they still prevail. Okay? And if there are any, I haven't checked, but there were no discussions about it. This may refer to just the ordinal or cardinal sequence of the numbering of the provisions, but not as to the substance of the provisions under the revised rules of court as to the interpretation or construction of contracts or written instruments. Okay. But before we go to the rules of court, also in the case of Marquez versus Espejo, the Supreme Court held that when the parties admit the contents of written documents but put in issue whether these documents adequately and correctly express the true intention of the parties, the deciding body is authorized to look beyond these instruments and into the contemporaneous and subsequent actions of the parties in order to determine such intent. And that, well settled, is the rule that in case of doubt, it is the intention of the contracting parties that prevails. For the intention is the soul of a contract, not its wording, which is prone to mistakes, inadequacies, or ambiguities. To hold otherwise would give life, validity, and precedence to mere typographical errors and defeat the very purpose of agreements. Okay, in another case, Norton Resources and Development Corporation versus All Asia Bank Corporation. The Supreme Court held that the cardinal rule in the interpretation of contracts is embodied in the first paragraph of Article 1370 of the Civil Code. If the terms of a contract are clear and leave no doubt upon the intention of the contracting parties, the literal meaning of its stipulation shall control. This provision is akin to the plain meaning rule applied by Pennsylvania courts, which assumes that the intent of the parties to an instrument is embodied in the writing itself. And when the words are clear and unambiguous, the intent is to be discovered only from the express language of the agreement. It also resembles the Four Corners rule, a principle which allows courts in some cases to search beneath the semantic surface for clues to meaning, A court's purpose in examining a contract is to interpret the intent of the contracting parties as objectively manifested by them. The process of interpreting a contract requires the court to make a preliminary inquiry as to whether the contract before it is ambiguous. A contract provision is ambiguous if it is susceptible of two reasonable alternative interpretations, and where the written terms of the contract are not ambiguous and can only be read one way, the court will interpret the contract as a matter of law. If the contract is determined to be ambiguous, then the interpretation of the contract is left to the court to resolve the ambiguity or ambiguity in the light of the intrinsic evidence. Okay. So, as to the last part of our discussion, in 1379, referring to the Rules of Court, Rule 130 of the Revised Rules of Court, from Section 9 to Section 19. Okay. So in Section 9 of Rule 130, pertains to evidence of written agreements. When the terms of an agreement have been reduced to writing, it is considered as containing all the terms agreed upon. There can be, between the parties and their successors in interest, no evidence of such terms other than the contents of the written agreement. Okay, so however, a party may present evidence to modify, explain, or add to the terms of the written agreement if he puts in issue in his pleading an intrinsic ambiguity, mistake, or imperfection in the written agreement, the failure of the written agreement to express the true intent and agreement of the parties thereto, next, the validity of the written agreement, or the existence of other terms agreed to by the parties or their successors in interest after the execution of the written agreement. So the term agreement includes wills. Section 10, interpretation of a writing according to its legal meaning. The language of a writing is to be interpreted according to the legal meaning it bears in the place of its execution, unless the parties intended otherwise. Section 11, instrument construed so as to give effect to all provisions. In the construction of an instrument where there are several provisions or particulars, such a construction is, if possible, to be adopted as will give effect to all. Section 12. Interpretation according to intention, general and particular provisions. In the construction of an instrument, the intention of the parties is to be pursued. And when a general and a particular provision are inconsistent, the latter is paramount to the former. So a particular intent will control a general one that is inconsistent with it. Section 13. Interpretation according to circumstances. For the proper construction of an instrument, the circumstances under which it was made, including the situation of the subject thereof and of the parties to it, may be shown, so that the judge may be placed in the possession of those whose language he is to interpret. Section 14. Peculiar signification of terms. The terms of a writing are presumed to have been used in their primary and general acceptation, but evidence is admissible to show that they have a local, technical, or otherwise peculiar signification, and were so used and understood in the particular instance, in which case the agreement must be construed accordingly. Section 15. Written words control printed. When an instrument consists partly of written words and partly of a printed form, and the two are inconsistent, the former controls the latter. Section 16. Experts and interpreters to be used in explaining certain writings. With the characters in which an instrument is written were difficult to be deciphered or the language is not understood by the court, the evidence of persons skilled in deciphering the characters or who understands the language is admissible to declare the characters or the meaning of the language. Section 17 of two constructions which preferred. When the terms of an agreement have been intended in a different sense by the different parties to it, that sense is to prevail against either party in which he supposed the other understood it, and when different constructions of a provision are otherwise equally proper, that is to be taken which is the most favorable to the party in whose favor the provision was made. Section 18. Construction in favor of natural right. When an instrument is equally susceptible of two interpretations, one in favor of natural right and the other against it, the former is to be adopted. And finally, Section 19. Interpretation according to usage. An instrument may be construed according to usage in order to determine its true character. So, that ends our lecture for today and the lecture for the semester. So, you may ask about the coverage of the final exams. Well, I am inclined to include extrinsic aids, intrinsic aids, and all of the subject matters or topics that I have discussed, including Latin legal maxims and amendment and repeal, prospectivity, retrospectivity, interpretation of contracts, and general principles or general rules of construction. So with that, I hope you learned something in today's discussion, and I hope that you will stay safe, you will stay healthy, and you will continue to pray and always remember to glorify God with a grateful heart. Thank you very much. See you soon. Good luck with the final exams. God bless you all.